David Joseph Pittman. The Pittman case is emblematic of cruel violence. David Joseph Pittman, 63, was convicted in 1991 of the brutal murder of his ex-wife's parents and sister during a contentious divorce proceeding in Polk County. Governor Ron DeSantis signed David Joseph Pittman's death warrant on August 15, 2025, scheduling his execution for September 17, 2025, marking Florida's 12th execution of the year. This is the story of a life marked by cruel violence and the inexorable march towards a definitive sentence. 3 decades after his death sentence, all appeals have been unsuccessful. Pittman will be executed at Florida State Prison in Stark, with lethal injection as the prescribed method. Please like and subscribe if you're new to the channel. A childhood marked by abuse and violence. David was never able to succeed in school. His grades rose rarely a D or an F. His parents were too poorly and dysfunctional to provide him with the help he has needed, ending psychiatric care after only a few visits because they couldn't afford it. From childhood, David hardening horrific abuse. His mother admitted to beating him every day, every other day, wearing belts, broom handles, and even Hot Wheels tracks. She testified that she sometimes has been the shit out of him. At age 6, David was knocked unconscious while trying to siphon gas. He was also subjected to severe neglect. He was 11, forced to sit on a bench in the kitchen for 7 straight days after pouring a can of stain. Later, expert testimony revealed that David was also sexually abused as a child by a babysitter, neighborhood kids, and the owner of the gas station where he worked. He has started gas station and used drugs as a teenager, further compounding the brain damage and trauma from years of violence. His IQ was tested at 70 and 71 before age 18. He was placed in special education. He had documented brain damage, and there were medical evaluations reaffirming his condition. The murders. David and Barbara Marie were the parents of 3 young children who normally were living with their maternal grandparents, Clarence and Barbara Knowles, at 500 Northeast 4th Street. The children were Cindy Pittman, date of birth January 13, 1886, Robin Pittman, date of birth March 17, 1887, and Wendy Pittman, date of birth December 27, 1888. They were now divorcing. David had said he would hurt her and her family if he divorced. Furthermore, Marie's sister, Bonnie Knowles, claimed that David had sexually abused her in 1985, 5 years before the divorce. The night of May 14, 1990, Pittman went to the Polk County home of his wife Marie's parents, Clarence and Barbara Knowles, during their divorce proceedings. Pittman was in the presence of others who could vouch for his whereabouts up until 2:30 a.m. on the morning of May 15, 1990. From 2:30 a.m. until 3:30 a.m., no one was with David and able to vouch for his whereabouts. It was in that 1-hour period that the state argued that Mr. Pittman committed the murders. This left a 40-minute window, according to the state, for Mr. Pittman to walk from his father's house to the Knowles home, enter the house. It was 1/2 mile, a 13-minute walk, from the Pittmans to the Knowles. There, David cut the telephone lines that connected to the outside of the house. Upon entering the victim's home, he systematically murdered all the occupants with a weapon that minimized the possibility of attracting the attention of witnesses. Bonnie Knowles had been fatally stabbed 8 times. Bonnie Knowles' throat had been cut. 6 of the wounds were sufficiently serious to have caused death on their own. Barbara Knowles was murdered at 2:45 a.m. Barbara Knowles' body, the medical examiner found 3 stab wounds, 1 to the neck and 2 in the chest. The 2 wounds to the chest were fatal. Death would have been fairly rapid, maximum 5 minutes, because they hit the aorta. The burning of Barbara's body also occurred post-mortem. In his examination of Clarence's body, the medical examiner found 5 stab wounds. 1 wound was superficial. The other 4 penetrated the pleural cavity and were lethal. As with Barbara, Clarence would have died from massive bleeding within minutes. The burns to the body would have been post-mortem because there was no soot in his airways and blood test was negative. Pittman fatally stabbed the elderly couple along with their youngest daughter, Bonnie. A detective with the Polk County Sheriff's Office opined that a flammable liquid was poured throughout the living room and into a hallway. It was determined that there was a good possibility that the flammable liquid was poured on furniture in the living room. There was also a fire trail that came out of the residence. This trailer extended approximately 15 feet. The bedroom in which Bonnie Knowles was found contained the heaviest damage. This was because an automobile tire had been placed under the approximate center of the bed. This caused the fire to burn very hot in that bedroom. He then set the house on fire, stole Bonnie's car, and burned it. Testimony at the trial revealed that he understood the use of fire to destroy evidence. Before setting the fire, however, he secured the keys to Bonnie Knowles' car for the purpose of his getaway. The record reflects that, shortly after 3 a.m. on May 15, 1990, a newspaper delivery man in Mulberry, Florida, reported to law enforcement authorities that he had just seen a burst of flame on the horizon. When the authorities investigated, they found the home of Clarence and Barbara Knowles fully engulfed in fire. After the fire was extinguished, the police entered the house and discovered the bodies of Clarence and Barbara, as well as the body of their 20-year-old daughter, Bonnie. Although all of the bodies were burned in the fire, a medical examiner determined that the cause of death in each instance was massive bleeding from multiple stab wounds. In addition, the medical examiner testified that Bonnie Knowles' throat had been cut. A subsequent investigation revealed that the fire was the result of arson, that the phone line to the house had been cut, and that Bonnie Knowles' brown Toyota was missing. A construction worker testified that when he arrived at work at 6:30 a.m. on the morning of the fire, he noticed a brown Toyota in a ditch on the side of the road near his job site. Other testimony revealed that the location of the Toyota was about 1/2 mile from the Knowles residence. The worker also observed a homemade wrecker, which he later identified as belonging to Pittman, pull up to the Toyota and, shortly thereafter, saw a cloud of smoke coming from that direction. Another witness who lived near the construction site also saw the smoke and observed a man running away from a burning car. This witness later identified Pittman from a photo pack as the man she saw that morning. Investigators determined that the car fire, like the earlier house fire, was the work of an arsonist. The record further reflects that Pittman feared that the police suspected his involvement in the murders, and, at the prompting of his mother, Pittman turned himself into the police on the day after the murders. Trial and sentencing. At the time of the murders, another of the Knowles daughters, Marie, was in the process of divorcing Pittman. The divorce was not amicable, and the state introduced testimony that Pittman had made several threats against Marie and her family. The state also produced evidence that Pittman had recently learned that Bonnie Knowles had tried to press criminal charges against him for an alleged rape that had occurred 5 years earlier. Carl Hughes, a jailhouse informant, testified that Pittman told him that he had gone to the Knowles house on the evening of the murders to speak with Bonnie Knowles about the problems he was having with her family. Bonnie let Pittman in the house and, when she refused his sexual advances, he killed her to stop her cries for help. Pittman then admitted to killing Barbara Knowles in the hallway outside Bonnie's bedroom and to killing Clarence in the living room as Clarence tried to use the phone. Pittman also told Hughes that he burned the house, stole the Toyota, and abandoned it on the side of the road, and later returned to the Toyota and burned it as well. David Pittman was convicted and sentenced to death for the murders of Clarence, Barbara, and Bonnie Knowles. Clarence and Barbara Knowles' daughter, Marie, was married to Pittman. Marie initiated a divorce, which Pittman did not want. During the course of the divorce, Pittman had threatened to harm both Marie and her family. In the early morning hours of May 15, 1990, witnesses phoned the fire department to report that the residence of Clarence and Barbara Knowles, Marie's parents, was on fire. It was discovered, after the investigation, that the perpetrator had cut the phone line, and after setting the fire stole the car of Bonnie Knowles, the couple's other daughter. The bodies of Clarence, Barbara, and Bonnie were found in the home. The cause of death for all three was attributed to multiple stab wounds, which resulted in massive bleeding. Additionally, Bonnie Knoll's throat had been slit. Another witness testified that on the same morning of May 15, 1990, he saw a car similar to Bonnie Knowles's in a ditch on the side of the road close to the Knowles's home. This witness saw a truck, determined to belong to Pittman, pull beside the car. The witness later noticed the car on fire. Another witness saw a man running from the burning car and later identified the man as Pittman in a photo lineup. Evidence against Pittman included eyewitness testimony from someone who saw him running from the burning car and jailhouse informant testimony that Pittman had confessed to the killings. A jury convicted him on 3 counts of first-degree murder, plus arson and grand theft charges. If the fire was started a half hour before discovery, then there may have just been enough flammable liquid used to get the normal combustibles in the living room burning. In the penalty phase, the state established that Pittman was convicted of aggravated assault in 1985. In mitigation, Pittman presented the testimony of his mother that he was a difficult child to deal with and that she had disciplined him severely. A clinical psychologist testified that Pittman's father was a paranoid schizophrenic, that as a child Pittman suffered from a severe attention deficit disorder with hyperactivity, and that Pittman has organic personality syndrome, which causes paranoia and an unstable mood. After hearing this testimony, the jury recommended the death penalty for each murder conviction by a vote of 9-3. In his sentencing order, the judge found 2 aggravating circumstances for each murder: previous conviction of another capital or violent felony, and the murders were heinous, atrocious, or cruel. The judge then expressly rejected the mitigating factors of Pittman's being under the influence of extreme mental and emotional disturbance, and concluded that the aggravating factors outweighed the proven mitigating factors. The judge imposed the death penalty for each murder. Appeals. On September 16, 1991, Pittman filed his direct appeal to the Florida Supreme Court. In his appeal, he contended that the court incorrectly admitted evidence of his past crimes. Pittman also claimed that the trial court admitted identification testimony that was manipulated by suggestive procedures. Some of Pittman's other claims included hearsay evidence of someone else's involvement in the murder was not admitted, and the judge rendered an insufficient sentencing order, which imposed 3 death sentences. The court found no merit in any of Pittman's claims and affirmed his convictions and sentences on September 29, 1994. On March 20, 1995, Pittman filed a petition for writ of certiorari, which was subsequently denied on May 15, 1995. On March 24, 1997, Pittman filed a 3.850 motion to the Circuit Court. The motion was dismissed on April 24, 1997. Subsequently, he filed an amended 3.850 motion on November 2, 2001. On September 15, 2005, Pittman filed a second amended 3.850 motion. On May 8, 2006, the evidentiary hearing was held. If all appeals are unsuccessful, Pittman will be executed at Florida State Prison in Starkey with lethal injection as the prescribed method. Of death and date of execution. The compressed schedule leaves little room for error or delay. Pittman is scheduled to be executed by lethal injection on September 17, 2025 at 6 p.m. at the Florida State Prison in Stark. The death injection, a mixture of 3 drugs, a sedative, a paralytic, and a drug that stops the heart, will be administered via the bloodstream, according to the State Department of Corrections. Once the lethal injection is administered, the date and time of death will be medically confirmed. His death will bring a long judicial process to a close so that after 3 decades, the victims' families can finally feel that justice has finally been done. Florida's record-breaking pace of executions shows no signs of slowing, and more death warrants are expected as Governor DeSantis continues his efforts to reduce the backlog of more than 300 inmates on death row, which has placed Florida at the center of the national debate over the death penalty. Aftermath. Florida's accelerated execution pace has reignited broader questions about the death penalty in the United States. Supporters of capital punishment argue that the state is finally addressing decades of legal inertia and delivering long-overdue justice to victims' families. They contend that the death penalty serves as a deterrent and a necessary tool for the most heinous crimes. Governor DeSantis, for his part, has repeatedly emphasized his commitment to upholding the law and ensuring that sentences handed down by juries are carried out without undue delay. Opponents, however, raise concerns about the risks of wrongful convictions, the uneven application of the death penalty, and the ethical implications of state-sanctioned execution. They point to the lengthy and costly appeals process, the potential for judicial errors, and the disproportionate impact on marginalized communities. Nationally, the debate remains as polarized as ever, with some states moving to abolish capital punishment altogether, while others, like Florida, double down on its use. The Pittman case is emblematic of these tensions. On one hand, the brutality of the crime and the weight of the evidence have left little doubt in the minds of many Floridians about the appropriateness of the sentence. On the other, the relentless pace of executions and the sheer number of death warrants issued this year have prompted renewed scrutiny from legal experts, advocacy groups, and international observers.